Hello ma'am, hello classmates, and today I will discuss the executive clemency. First, I will define executive and clemency. So, executive, it is the branch of the government. So, we have three branches of government, the like legislative, judiciary, and the executive branch. So, ang executive branch, ito ang inire-represent ng ating Pangulo na tinatawag rin natin na Chief Executive. At ang clemency naman ay ang other term is forgiveness o kapatawaran. So, pag pinagsama natin ang executive at clemency, ang executive clemency ay ang kapatawaran na ibinibigay ng ating Pangulo. So, executive clemency, the power of a president in federal criminal cases and the governor in state convictions to pardon a person convicted of a crime, commute the sentence, shorten it often to time already served, or reduce it from death to another lesser sentence. There are many reasons for exercising this power, including real doubts about the guilt of the party, apparent excessive sentence, humanitarian reasons such as illness of an aged inmate, to clear the record of someone who has demonstrated rehabilitation or public service, or because the party is a political or personal friend of the governor. So sinasabi dito na ang executive clemency ay the power of a president to reduce the sentence, cancellation of sentence, and also the lowering of a sentence for a person who is being convicted or sentenced by the final judgment. So, next is, how may executive clemency be exercised? First, the reprieve. Second, absolute pardon. 3, conditional pardon, and commutation of sentence. So, here is the reprieve refers to the deferment of the implementation of the sentence for an interval of time. It does not annul the sentence but merely postpones or suspend its execution. So ang reprieve ay temporary suspension of the execution of a sentence, especially the sentence of death. So sa reprieve, hindi pagpapawalang bisa sa isang tao na nagkasala, pero ito ay ang postponement for the execution of judgment. So the keywords here in the reprieve ay the cancellation of sentence, postponement of sentence, and temporary stay of sentence. Next is absolute pardon. It is the total extinction of the criminal liability of the individual to whom it is granted without any condition whatsoever, resulting to the full restoration of his civil rights. So in absolute pardon, ito yung without any condition. My example here is the former president Joseph Estrada, na binigyan ni former President Gloria Macapagal Arroyo ng absolute pardon to cancel his case, just like in the case of plunder. So next is conditional pardon. It is the condition exemption of a guilty offender for the punishment imposed by a court. So in conditional pardon, ito yung may condition o may limit. Nakalaya ka pero may mga dapat kang sundin. The pardonee is under obligation to comply strictly with the conditions imposed therein, otherwise his non-compliance will result to the revocation of pardon. So dito sa conditional pardon, pwedeng mabawi ang pardon na binigay sa kanya at makakasuhan pa siya ng criminally liable bilang isang pardon violator. And the last one is commutation of sentence. It is the reduction of the period of a prison sentence. um, so sa commutation sentence, it is an executive clemency which changes heavier sentence to a less serious one or a longer prison to term to a shorter one. Ang mabigat ay pinapagaan at ang mahaba ay pinatikli. It is granted by the President. So in commutation sentence, ang tatandaan lang natin ay yung keyword ng reduction of sentence, lowering of sentence, shortening of sentence, and transforming of sentence.
Commutation. In law, a commutation is the substitution of a lesser penalty for that given after a conviction for a crime. The penalty can be lessened in severity, in duration, or both. Unlike most pardons by government and overturning by the court, a fulfilled overturning is equal to acquittal. A commutation does not affect the status of defendant's underlying criminal conviction. Although, the concept of commutation may be used to broadly describe the substitution of a lesser criminal penalty for the original sentence. Some jurisdictions have historically used the term only for the substitution of a sentence of a different character that was originally imposed by the court. For example, the substitution of a sentence of parole for the original sentence of incarceration. A jurisdiction that uses the definition of commutation will use another term such as remission to describe a reduction of a penalty that does not change its character. Commutation in commutation in the U.S. The president can commute or reduce sentences for federal convictions, meaning the president may substitute a less severe punishment in place of punishment originally imposed. A sentence may be commuted when facts become known that were not known at the time of sentencing or that came to light and were developed after. Commutation typically occurs in cases of old age, illness, and when the sentence is unusually harsh compared with similar cases. When a citizen, only a subsequent pardon can do that, which sometimes happen. While commutations have been rare in the past, President Obama granted a record of 1,715 commutation to acknowledge rehabilitation effort and second chances.
Does the President have absolute power to commute sentences and pardon convicts? The answer is no. The power of the President to pardon convicts is not absolute. Citing the limitation of presidential pardon, lawyer Christian Monsod, one of the framers of the 1987 Constitution, said it cannot be appealed under the following circumstances. 1. The conviction is not final or on appeal. Second, the convict committed an election crime for which the recommendation of the Commission on Election is required. Article 9, Section 5. And third, the convict is facing an impeachment case. Monsod said presidential pardon is also subject to the power of judicial review, based on the principle of separation of powers and of checks and balances in the Constitution. He added that, depending on the fact of each case, pardons are reversible if any of the expectation to the presidential power is ruled as ultimately valid by the Supreme Court. But according to Article 72 of the Constitution, the President shall have the power to grant pardons, reprieve, respites, or remissions of punishment, or to suspend, remit, or commute the sentence of any person convicted of any offense where the sentence is a sentence of death. A parallel power is also given to the governor of the state under Article 161.
So good day everyone, I am Chuchi Antalan and I will be discussing to you the reprieve. So ano nga ba itong tinatawag nating reprieve? It refers to deferment of the implementation of the sentence for an interval of time. It does not annul the sentence but merely postpones or suspends in its execution. So that is what we call reprieve.
Good day everyone, I'm Antalan Janet Depi, Criminology 3. Today I'll be discussing the presidential pardon. A presidential pardon is an act of grace from the chief executive absolving inmates or persons deprived of liberty, PDLS, from the punishments prescribed for the crime he has committed according to the Department of Justice. The power to pardon from executive clemency is given to President under Article 7, Section 19 of the 1987 Philippine Constitution, except in a case of impeachment or as otherwise provided in the Constitution, the President may grant reprieve, constitutions and pardons, and remit fines and forfeitures after conviction by final judgment. He shall also have the power to grant amnesty with the currency of majority of all the members of Congress. So, what are the limitations of presidential pardons? First is impeachment cases. Second, convictions is on appeal, not final. Third, election offense, recommendations of COMELEC is required. What are the types of presidential pardon? First, absolute pardon. Second, conditional pardon. Absolute pardon, it totally extinguishes criminal liability of an individual without any condition. This restores PDLs, civils, and political rights. It exempts the individual from the penalty of the crime he has committed. Absolute pardon is a complete acceptance. Who may qualify for absolute pardon? First, those who have already served their maximum sentence. Second, those who were discharged to parole. Third, those who received court terminations of probation. Second, conditional pardon. It exempts an individual within certain limits of conditions from punishment. It results in the partial extinctions of criminal liability. Acceptance by grantee in needed. It is a contract between President and the convict that former will release the letter upon compliance and conditions. Who may qualify for conditional pardon? Those who have served at least one half of minimum original sentence. That's all.
Commutation does not reserve a conviction and the recipient of a commutation remains guilty in accordance with the original conviction. For example, someone convicted of capital murder may have their sentence of death commute to life imprisonment, a lessening of punishment that does not affect the underlying criminal conviction, as may occur on a discretionary basis or following upon the change in the law or judicial ruling that limits or eliminates the death penalty. In some jurisdiction, a commutation of sentence may be conditional, meaning that the convicted person may be required to abide by specific conditions or may lose benefit of the commutation. The condition must be lawful and reasonable and will typically expire when the convicted completes any remaining portion of his or her sentence. For example, the pardon may conditioned upon the penalty being a law-abiding citizen, such that if the beneficiary of the commutation commits a new crime before the condition expires, the original sentence may be restored.
Does the President have absolute power to commute sentences and pardon convicts? No. The President doesn't have absolute power to commute sentences and pardon convicts because there are limitations of such power. One of the limitations is no pardon may be granted in impeachment cases. Another one is no pardon may be granted when otherwise provided in the Constitution, especially in Section 5, Article 9C, which clearly state that no pardon, amnesty, parole, or suspension of sentence for violation of elections law, rules, and regulations shall be granted by the President without the favorable recommendation of the COMELEC. Except for these cases, the President may grant reprieves, commutations, and pardons, and remit fines and forfeitures after the person is convicted by final judgment. When we say commutation of sentence, it is when a person is not absolved from conviction completely, but his punishment is substituted or replaced with a lesser punishment. The president also have the power to grant amnesty with the concurrence of majority of all the members of the Congress.
Good day, ma'am. I am Carlo Bautista from Grade 3E. So, what does the grant of presidential pardon mean? So, in Article 72 of the Constitution, gives the President the right to grant pardons, remit, or compute the sentences of anyone convicted of any crime. The power to pardon is exercised by the President on the advice of the Council Minister. So, pardoning power of the President's consent and purpose. Pardon may substantially help in saving an innocent person from being punished due to miscarriage of justice or in cases of doubtful conviction. It also gives hope of being pardoned itself serve as an incentive for the convict to behave himself in the prison institution and thus helps considerably in solving the issue of prison discipline. It is always preferable to grant liberty to a guilty offender rather than sentencing an innocent person, and the object of pardoning power is to correct possible judicial errors, for no human system of judicial administration can be free from imperfections. The very essence of pardon is forgiveness or remission of guilt, according to the 1989 Supreme Court ruling Musanto v. Factoran Jr. Pardon implies guilt. It does not erase the fact of the commission of the crime and the conviction thereof. It does not wash out the moral stain. It involves forgiveness and not forgetfulness.
Good day, ma'am. I'm Samuel Ambulosan Jr. Presidential pardon. What is a presidential pardon? A pardon is an act of grace from the chief executive absolving inmates or persons deprived of liberty or PDLs from the punishment prescribed for the crime he has committed according to the Department of Justice. Pardon, ang act na ito ay nagpapatawad o pagpapatawad sa isang kamalian o kasalanan ng isang person deprived of liberty. The power to pardon, a form of executive clemency, is given to the President under Article 7, Section 19 of the 1987 Constitution. Sinasabi dito, maliban sa mga kaso ng pagpapatupad o bilang kung hindi man ibigay sa saligang batas na ito, ang Pangulo ay maaaring magbigay ng reprieves, komunikasyon at pardons, at muling mag-remit ng mga fine at mga forfeitures. Pagkatapos ng pananalig sa pamamagitan ng huling paghuhukom, siya rin ay magkakaroon ng kapangyarihang magbigay ng amnestiya sa pagkalito ng karamihan ng lahat ng mga miyembro ng Kongreso. At does the President have absolute power to commute sentences and pardon convicts? No, the power of the President to pardon convicts is not absolute. Citing the limitations of presidential pardon, Attorney Christian Monsod, one of the framers of the 1987 Constitution, said it cannot be applied under the following circumstances. The conviction is not final or an appeal. The conviction committed an election crime for which the recommendation of the Commission. An election is required under Article 6, Section 5, and lastly, the convict is facing an impeachment case. Monsod said presidential pardon is also subject to power the judicial review based on the principles of separation of powers and of checks and balances in the Constitution. He added that, depending on the facts of each case, pardons are reversible if any of the exceptions to the presidential power is ruled as ultimately valid by the Supreme Court. What does the grant of presidential pardon mean? The very essence of pardon is forgiveness of or remission of guilt according to the 1989 Supreme Court ruling Monsanto versus Factoran Jr. Sinasabi doon na pinapahiwatig ng parusa ang kasalanan, ito ay hindi burahin ang katunayan ng komisyon ng krimen at pananalig niyon. Hindi nito husgahan ang moralidad, ito ay nagsasangkot ng pagpapatawad at hindi kalimutan. Next is what are the types of presidential pardon? Conditional pardon, which exempts an individual within certain limits or conditions from punishment of his or her crime committed, resulting in the partial extinction of his or her criminal liability. If delivered and accepted, it is contract between the executive and the convict that former will release the later upon compliance with the condition. Example of a condition: not to violate any penal laws of the country again.
Next to the types of presidential pardon is the absolute pardon. So what is absolute pardon? Absolute pardon, which totally extinguishes criminal liability of an individual without any condition. Criminal liability means a person is responsible for any illegal behavior that causes harm or damage to someone or something. A person is liable or responsible for a crime when he or she has acted with criminal intent, as opposed to acting accidentally or lacking the ability to act deliberately. Absolute pardon restores the individual's civil and political rights and remits imposed penalties for the particular offense he or she was convicted. What do we mean if we say civil and political rights? Civil and political rights are a class of rights that protect individuals' freedom from infringement by governments, social organizations, and private individuals. They ensure one's entitlement to participate in the civil and political life of society and the state without discrimination or repression. Civil and political rights are among the best-known human rights, covering freedom from discrimination and the right to privacy, as well as the right to peaceful assembly, freedom of expression, the right to vote, and freedom of religion. Absolute pardon is an act of grace proceeding from the power entrusted with the execution of the laws, exempts the individual from the penalty of the crime he has committed. This is solely based on the discretion of the President, and there can be no other condition imposed herein. The President is the supreme power in granting this executive clemency. Supreme power is the highest authority in a state, all other powers in it being inferior thereto. So what is executive clemency again? As what Mr. Agag discussed a while ago, executive clemency is the power of a president in federal criminal cases and the governor in state convictions to pardon a person convicted of a crime, commute the sentence, or reduce it from the death to another lesser sentence. Executive clemency refers to either the commutation of sentence, absolute pardon, and conditional pardon, with or without parole conditions as may be granted by the President upon recommendation of the Board. Absolute pardon is complete even without acceptance, whereas a conditional pardon has no force until it is accepted by the condemned. Remember that absolute pardon is the total extinction of the criminal liability of the individual to whom it is granted without any condition whatsoever, resulting to the full restoration of his civil rights.
Next is who may qualify for a president pardon. So the Board of Pardons and Parole, or the BPP, which is under the office of the Secretary of Justice, they are the one who will review the applications for parole or conditional pardon, and they are the one who will recommend to the President for the executive clemency. So they are the one who will release the prisoners on parole and recommends the grant of presidential pardon, which is they supervise the rehabilitation of parolees as well as the probationers. So the BPP is also the collegial body created by the virtue of the Republic Act number 4103, which is the indeterminate sentence law, as amended with the duty to look into the physical, mental, and criminal record of all the prisoners eligible for the parole and to determine the proper time for the release of those prisoners. So what is their basis of the Supreme Court through the BPP in granting the parole? So it is granted by the BPP whenever it finds that there is reasonable probability that if the prisoner will release he will become or he is a law-abiding, and that the release will not be in conflict with the interest and the welfare of the society. So as they discussed a while ago, that there are two types of presidential pardon, which is the conditional pardon and the absolute pardon. As recall, pag sinabi natin conditional pardon, ito yung palalayain yung isang nabilanggo, ngunit but there is a condition which required yung mga otoridad na bumisita doon sa prisoner or the released prisoner. And it is a conditional exemption of a guilty offender for the punishment imposed by the court. And also, a person granted with a conditional pardon is required to abide by the limits and guidelines imposed. So that person is also required to be under the supervision of a pardon officer. And kapag hindi siya nag-comply doon sa mga requirements na binigay ng korte, is the result in the revocation of, or it will be resulted into the revocation of the pardon. So who may qualify or who may file a petition for the conditional pardon? So a prisoner who has served at least one half of the maximum of the original indeterminate or definite prison term. So kapag yung maximum ng sentence is 4 years, and natapos na yung years na yun or na-serve niya yung sentence na 4 years, is pwede na siyang mag-petition or mag-file ng petition for conditional pardon. And also for the absolute pardon, as I recall, kung sakaling mababasbasan yung pagkabilanggo ng isang prisoner is maibabalik or muling maibabalik yung civil rights niya, yung political rights niya, and also magiging malinis yung criminal record niya. And it is a total extinction of the criminal liability of the individual to whom it is granted without any condition and whatsoever, resulting to the full restoration for his civil rights. And who may file for a petition of absolute pardon? So one may file a petition for absolute pardon if the maximum sentence is served or granted final release and discharge or court termination of probation. And also, the board may also consider a petition for an individual even before the final release when a petitioner is seeking new appointive or elective public position or reinstatement in the government service. Next is suffering from a serious physical or mental disability, needing medical treatment abroad which is not available in our country or locally, and taking any government examination or immigrating.
Good day everyone, I'm Carla Dulu from BS Spring 3 Echo, and I'm going to discuss about amnesty and the issues confronting the Philippine correction, which has become the consideration for the granting of executive clemency. First, I'm going to talk about amnesty. What is amnesty? Amnesty is an act of oblivion, or it is the sovereign act of oblivion from the past acts by the government to the group of people who committed an offense, particularly a political offense. Just like political crime against the state, such treason, rebellion, and sedition. Amnesty is applied retroactively, and it seeks to erase all criminal records of this group people, whether they convicted or not. And for example, in United States, in a foreign citizen to help protect the citizens from being killed in his own country. And when a criminal is told to go free, and there are distinctions between pardon and amnesty. Amnesty is a public crime, while pardon is an infraction of the peace of private crimes. Amnesty is class. The grantee is the group of person, while pardon is the grantee is individual. And as to the need of Congress concurrence, pardon is not necessary, while amnesty is necessary. And the distinct act of acceptance by the grantee is needed in pardon, while in the amnesty, the grantee need not accept. And pardon only relieves the offender from the consequence of the offense, while amnesty abolishes the offense, and the pardon may be granted only after conviction, while amnesty is be granted before or after the conviction with the final judgment. In United States politics, 1872, restoring the right to vote and hold office to ex-Confederates, those who are the true amnesties past violations without changing the law. The, who qualifies amnesty in the United States? They should be one must prove continuous unlawful residence who maintain illegal immigration status are ineligible to be legal permanent residents. Amnesty in United States is to grant those who have committed an offense under immigration law is a governmental pardon for a person of group who violated policies related to immigration. Immigration amnesty is included the government forgiving individual for using forged document. And amnesty is the compassionate component in the administration. And amnesty aims to reduce the level of illegal migration and residence in US. In United States, it states that who convicted of one felony or 3 or more misdemeanors are not eligible. Application will be taken over 12 months period beginning not later than 6 months after the law is enacted. And we're going to discuss the issues confronting the Philippine correction system, which has become the consideration for the grant of executive clemency. Here, first issues is all about the overcrowding of certain prison institutions, jails. Overcrowding means the jail is not sufficient for the detainee. Second, fragmented setup of the correction system. Third, the lack of information technology system and expertise means they are not skilled. And third, lack of inadequate training or what we call lack of awareness and understanding by some prison jail officials and staff on the rights of the inmates. The petitions for parole shall be addressed to the chairman or the executive director of the board. And the prisoner who escaped or evaded service of sentence are not eligible for executive clemency for a period of 1 year from date their last recommitment to a prison or conviction for evasion service sentence.
So good day everyone, I'm David Mark Rafael B. from CRIM 3 and I will gonna discuss to you the basis for grant of executive clemency. So basis for grant of executive clemency, the BPP or what we call the Board of Pardon and Parole recommends the President of the grant of executive clemency when any of the following circumstances are present. So number 1 will be the trial or the appellant court recommended in its decision na grant of executive clemency to the prisoner. So number 2, under the peculiar circumstances of the case, the penalty imposed is too harsh compared to the crime committed. So ito po is too harsh or hindi suitable o hindi angkop yung naipataw na penalty sa crime na committed ng prisoner. So, offender qualifies as a youth offender at the time of commission of the offense. So, nung na-commit yung crime is, yung offender natin o yung perpetrator natin is binata pa noon as a youth offender. So, number 4 will be the prisoner is 7 years old and above. Number 5 will be the prisoner is terminally ill. Number 6, alien prisoners were diplomatic consideration and amity among nations necessity review. And the last one is other similar or analogous circumstances whenever the interest of justice will be served thereby. So when application for executive clemency will be not favorably acted upon to the or by the Board of Pardon and Parole. So kailan hindi favorable yung pag-execute ng executive clemency sa ating mga prisoners. So number 1 will be the convicted of evasion of service and sentence. Number 2, who violated the conditions of their conditional pardon. Yung mga hindi sumusunod sa mga condition kung sila ay napatawan ng conditional pardon. So number 3, who are habitual delinquents or recidivists. Ito yung mga kriminal na ginagawa nila paulit-ulit yung kanilang crime and labas-pasok sila sa kulungan. And kahit hindi pa nila tapos yung pagsaserve ng kanilang final judgment is gumawa sila ulit ng crime na katulad ng nature ng kanilang previous crime. So number 4 will be the convicted of kidnapping for ransom. So number 5, convicted of violation of the Dangerous Drugs Act of 1972 and the Comprehensive Dangerous Drugs Act of 2002. So number 6 will be convicted of offense committed under the influence of drugs. So ito yung mga criminal na gumawa ng crime while they are on influence or while they are under the influence of drugs. Any drugs will be applicable to this one. So the last one is whose release from prison may constitute a danger to society. Hindi lahat kasi ng pinapalabas sa kulungan is nagbago na. Meron pa rin na bumabalik sa kanilang previous career. Kaya sinabi nila na ang correction sa ating pillar is ito yung pinaka-weak. Kasi may mga criminal pa rin na gumagawa or bumabalik sa kanilang dating buhay after nilang makulong ng several years. So that's all. Thank you.